We always want to take a hard look at these. When somebody is making a claim and saying, nope, this is a secular claim, it just happens to involve the church, you have to look a little bit more closely sometimes and determine what's actually going on here. Is there a church autonomy problem lurking beneath the veneer of a secular claim, in this case, fraud? Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Joseph Clement, Content and Program Manager at Napa Legal.
You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. So this week we'll be covering first a 10th Circuit case involving the Church Autonomy Doctrine in a trend of cases involving church autonomy that seems to be focused on the Mormons and the way that they tithe. Then we'll turn to a case that's being appealed to the U.S. Supreme Court involving a Christian baker that seeks to overturn Employment Division versus Smith, a case that we're really excited about following. And then we'll close by talking about a really fascinating district court judgment recently in Minnesota that rules against a Minnesota law that excludes religious schools from a generally available funding program. So let's dive in. First, we're going to go to the 10th Circuit and talk about this case involving the Mormon Church that has a really interesting result for the Church Autonomy Doctrine. So just by way of background, most of our listeners are already familiar with this, but the Church Autonomy Doctrine is the general principle derived from the First Amendment that prevents the judiciary from deciding matters of doctrine and religious belief. And so, for example, a court can't rule whether a particular religious tenet is true or false, or how it applies within a religious organization's governance, for example. And the important thing to note about the Church Autonomy Doctrine is it's not a court-created rule that says we choose not, as a secular court, we choose not to get involved in religious questions, but it's actually more of a jurisdictional doctrine saying that the secular courts don't have jurisdiction. They don't have the ability to decide these religious questions because they're outside of the scope of the judiciary's power. So this statement that a secular court can't determine whether a religious tenet is true or false seems obvious, but there are a lot of practical instances when this kind of thing comes up. And one of the recent trends, like I've said, has involved claims of fraud and misrepresentation by usually former members of the LDS Church, the Mormon Church, involving tithing practices, how the money's collected, and where it's spent. So this is another one of those cases. And here, the 10th Circuit recently affirmed the district court judgment dismissing a lawsuit against the Mormon Church after it was sued for fraud and racketeering. It was actually a RICO claim, which was something I've never seen applied to a Mormon tithing case. So in this case, several plaintiffs claim that the church misled congregants about the origins of Mormonism. It's kind of fascinating how historical and theological this claim is. So the court documents actually argue that Joseph Smith, the founder of the Mormon Church, did not actually translate the Book of Mormon in the manner that the church leadership had held, and that this misrepresentation allegedly led church members to tithe and attend services that they otherwise would not have attended, and tithes that they otherwise would not have given. So the court dismissed the RICO claim on the grounds that the claim required the court to decide a religious question. So this is a church autonomy decision. So the question was, are the beliefs being taught by the Mormon leaders being interpreted correctly? And the court, I think, rightly said, we're not going there. We can't go there. The tithing claim is a little bit different. The court actually noted that they didn't have to get to the church autonomy question here because the plaintiff has to show a causal link between the church's supposed misstatements about how it would use tithes and the plaintiff's alleged injury. And the court says that on its face, the claim from the plaintiffs here doesn't actually make the connection between the misstatements and the injury. So the bare bones elements of a fraud claim here were not even met. So they don't get into church autonomy on this second one, but they do on the RICO claim. And it's an interesting opinion. People who are following the development of the church autonomy doctrine in recent years should read this district court opinion. It's very good. So I just want to note, without going into too much detail, but that I think it's interesting that these claims seem to be coming in a recent wave, focusing on tithing practices and fraud claims in the Mormon Church. I'm not an insider into how the Mormon Church functions or what's going on there, but it's interesting, and I think it is going to end up helping to develop the church autonomy doctrine, especially on these fraud and misrepresentation claims. So This one is a little bit more of a straightforward church autonomy problem, but it shows a trend that I wanted to highlight. Plaintiffs are looking to characterize these claims not as the court addressing religious questions, but deciding secular legal claims like fraud, right? So that's always the argument. You're going to have, in these cases, the Mormon church saying, well, for the court to answer this, they have to answer religious questions about Mormon doctrine. That's impermissible under church autonomy. The plaintiffs who are suing are going to have to respond and say, no, these aren't about religious claims at all. These are straight fraud claims. We're saying that the church said something false, that the false statement led us to do something, that we were injured because of it. It's a straight secular fraud claim. You don't have to delve into religious doctrine at all. That's the fight. And it's actually trickier in a lot of these cases than it at first appears, right? So here, again, the argument would be the court doesn't need to interpret Mormonism. They just need to review the facts and conclude that the Mormon leadership is intentionally making misstatements in order to bring in members and therefore to bring in tithing dollars, right? That's the claim from the plaintiffs. These arguments can be kind of plausible at first, right? It's like, well, you don't actually have to delve into Mormon doctrine. You're just looking at did the Mormon church leader lie, and did that lie encourage people to come into the church and start giving money? So I think it's encouraging when we see courts take a harder look and kind of discern the religious questions that are often lurking beneath the secular legal claims. Here, I think it's easier to see what's going on, right? And the court notes this. In order to decide whether the Mormon leadership is committing fraud, the court would have to look into what true Mormon teaching about its origins actually is, right? It's not just a secular factual analysis of the law and the facts. It is a religious question. How did Joseph Smith write or translate the Book of Mormon? What does the original event in the Mormon church's history mean for Mormons today? How does the leadership communicate those things? These are religious questions, right? These are matters of preaching and teaching the Mormon religion. So to decide whether the Mormon leaders are speaking truly or whether they are speaking falsely is actually a religious question here. I think it's easier to see in this case. It was a little trickier in the Huntsman case that recently came down in the Ninth Circuit a few months ago, which I think is also worth highlighting. It's similar but a little bit distinct. There, the argument was particularly about the use of tithing funds, and part of it was some of the misrepresentation claims go outside of what I want to talk about here. But one of the questions in Huntsman was whether tithing dollars that the church leadership supposedly said would not be used for development projects in the area, but those tithing dollars were invested, and the interest that was being earned off of those investments was being used for development project. And there was this whole argument about, well, this was a misstatement. You said my tithing dollars weren't going to be used for development, and they are. And the Mormon church could respond and say, no, the interest is not tithing dollars. But a really interesting concurrence in that Huntsman case says, well, this gets into a religious question. Doesn't seem like it on the surface, just looks like a straight statement of where are the funds going? Are they actually going there? But really, what is a tithe? What is a tithing fund? Does it include interest? And also the concurrence in the Huntsman case as well. Hey, aren't Mormons required to tithe by being Mormons, regardless of whether interest might be invested or used for development projects? Is this really a misrepresentation that's reasonably being relied on by Mormons and whether they tithe, because they have to tithe anyway? And the point of that concurrence is not to defend the Mormon doctrine, but to point out these are religious questions. What is a tithe? Is the interest earned on a tithe investment also a tithe? These are religious questions. So I think it's just, I'll turn it over to you, Joseph, but I think it's just worth pointing out that we always want to take a hard look at these. When somebody is making a claim and saying, nope, this is a secular claim, it just happens to involve the church, you have to look a little bit more closely sometimes and determine what's actually going on here. Is there a church autonomy problem lurking beneath the veneer of a secular claim, in this case, fraud?
Yeah, there's a great line in the district court's opinion that really shows how this fraud claim really is at its heart a religious thing. It says a plaintiff alleging fraud must ultimately prove that a representation is false. But again, the truth or falsity of religious doctrine or beliefs is beyond the proper purview of secular courts and judges, right? So they would have to show that what the Mormon church leadership did was indeed fraudulent. It wasn't true. And what they were doing was a religious claim. So the court couldn't say that, oh, this claim is false, therefore it opens leadership up to a fraud claim. But let's say for a minute that the court actually did rule against Mormon leadership and said these were purely secular, right? Ultimately, that would open up the court's it would let them into a lot of internal decisions for religious organizations, right? So the Church Autonomy Doctrine is based, at least in part, on kind of this dual entity existence of churches, right? So churches exist as a corporation because they have to incorporate under American law, and they're kind of beset by a legal system within that. So on one hand, they have their legal existence. On the other, they also have a very real religious existence, right? And if this distinction starts to get eroded by courts, then churches can lose a lot of the capacities and capabilities that they need to exist, because every corporation has to make secular seeming decisions, right? Every organization needs to hire people. They need to buy property. They need to sign contracts. And for a church, many of these actions have a particularly religious animus to it. So if you want to hire people that align with your religious identity, right, there's actually a lawsuit against Liberty University right now over this. If you want to protect property that has a spiritual significance, again, another lawsuit over this. If you want to have access to fair agreements, again, more lawsuits, holy sexuality via sana, and various debanking things. And a lot of the lawsuits pending right now on these internal decisions aren't churches, but churches have to do the same things. Churches have to hire staff. They have to have property. And eroding that clarification that while churches have a legal existence, they also have an equally real and important religious existence. Usually the one, when this distinction gets eroded, the one that gets ignored is the religious one, right? So that it's kind of the one that's discarded of the two. And when this happens, distinct church autonomy ultimately just gets eroded. What happens is churches are forced to close down or face fines because they're not willing to violate their faith while they still have to do these corporate actions. So with that, we'll move into our second case, which is one we're really excited to keep tracking. So we'll talk about what happened when a Christian baker was sued for declining to bake a wedding cake for two women. So those familiar with the Jack Phillips case from Colorado that reached the Supreme Court a couple years ago will be pretty familiar with this fact pattern. Basically, this woman, Kathy Miller, opened up a bakery in California in 2013, so a little while ago. And she pretty quickly received a lot of kind of wild requests that went very much against her faith. And she started making policies where I won't make cakes that have, explicit imagery, that have demonic imagery. She won't make cakes for same-sex celebrations of legal marriages. And in one instance, two women approached her and said, "Hey, we want a cake for our wedding." She explained, "No, because of my faith, this is contrary to my religious beliefs about what marriage is, so I'm not going to be able to do this for you." She did refer them and say, "Oh, there's a different baker across the street or something that can help you with this." Very shortly after, she faced a lot of very obscene threats, so the kinds of things that I wouldn't want to repeat anywhere. And the two women who wanted the cake filed a lawsuit for violating California's public accommodation law. So Kathy Miller, the baker, won at the trial level and then lost at the appellate state level in California. And now she's appealing to the Supreme Court after the California highest court declined to hear it. So right now we're waiting to see if the court will take up her case. And this has massive legal significance. You might be thinking, why is this coming back before the Supreme Court? Didn't they kind of already decide on, can a baker refuse to bake a cake for something that they find religiously objectionable? And at one point, fair enough, this is kind of the same fact pattern, and you could certainly argue that California courts misinterpreted this law. But the big significance here that we want to zoom in on is the actual questions being presented. They're different from the Jack Phillips case, and they have massive implications for the religious liberty legal movement. So Miller's asking the court to answer three different things. So directly from the petition for cert, it says, one, whether the free speech clause's protection against compelled participation in a ceremony only applies where third parties would view that participation as expressing endorsement of the ceremony. Simple enough. So just to unpack that a little bit, basically the free speech clause protects against forcing somebody to participate in a ceremony, right? Compelled speech, compelled activity. And some people would argue that providing a wedding cake for a wedding is not an endorsement of that activity, right? Other people will say, no, it is when you provide kind of a service that's so central to the ceremony. It's an endorsement, but some people will say, no, this isn't an endorsement. So putting that kind of doubt aside, Miller's trying to make a bigger point here where she's saying, does the free speech protection apply even when people wouldn't see this participation as an endorsement? So am I still free to not be compelled to participate in an activity, even if it isn't necessarily an endorsement? So secondly, and this is starting to get to some of the Smith jurisprudence, Miller's asking whether proving a lack of general applicability requires showing unfettered discretion or categorical exemptions for identical secular conduct. So this is when we're getting into Smith, right? In the Smith case from the 1990s, the court ruled that a law that incidentally burdens religious exercise is subject to strict scrutiny only if that law is neither neutral nor generally applicable. And a big part of the generally applicable test is if there's these broad exemptions, right? So, for example, the Fulton case that was handed down a couple of years ago, where basically the city of Philadelphia said, we're not going to let this Catholic agency license foster parents because they're refusing to license same-sex individuals. The ruling there was that the law isn't generally applicable because there were these big exemptions where the head of the agency could kind of at her own discretion apply or not apply the regulations. So what's being asked here is if general applicability can be violated in ways other than these massive exemptions. So it could be in just kind of less broad exemptions, more nuanced ways, or in kind of different targeting of different groups. So this would really, if the Supreme Court takes this up, it could really weaken the requirements for a religious liberty infringement to trigger strict scrutiny. And out of that, more often than not, courts would rule in favor of the religious plaintiff. And then third, they just say straight up whether Employment Division v. Smith should be overturned. So the second question would weaken Smith. This third one is saying we should just get rid of it entirely. Miller and her attorneys are saying that the Smith precedent is very unclear. This causes a split in lower courts and that it causes bad decisions. And I love the last sentence of this opinion says, should this court determine that it must reconsider Smith, this case is an apt vehicle because it involves exactly the kind of religious testing of dissenters that the founders had learned to abhor. So this Smith precedent lets a lot of religious plaintiffs lose cases when they're being clearly discriminated against and when their free exercise is being very clearly and blatantly infringed upon. So ultimately, this comes down now.
Sorry, where is that quote? That quote about this being an apt vehicle to overturn or reconsider Smith, where did that come from?
Yeah, so this is the second to last opinion of the second to last sentence of the cert petition.
Okay, thank you.
Yeah, so ultimately now we're just watching if the court will take up this case, right? One of the questions presented in Fulton was the same, whether or not to overturn Smith. They ultimately decided not to just because of some different kind of qualifications within that case. But now we're just waiting to see if the court will take it up.
Yeah, I would just say that was a great summary of it. I just want to point out, I think it's a smart cert petition. I'm not sure if this court is ready to overrule Smith, but I like that the second question gives a kind of vehicle to chip away at or start to gut Smith. But it's interesting because the way I read it, the second question and the third question, right, whether general applicability should basically be narrowed or whether Smith should be overruled, they're getting down to kind of the same problem, right? So what the cert petition, as I understand it, is saying is, look, when we say a law doesn't need to be subject to strict scrutiny under the free exercise clause, if the law is, neutral and of general applicability, perhaps we're categorizing laws as neutral and generally applicable too often, right? Because a lot of the time they're worded as generally applicable. Yes, they apply to everyone, secular and religious alike. But when there's discretion in the enforcement, when there are certain exemptions for secular conduct, as you said, it's not really generally applicable. It's not really a neutral law. It looks like one, but upon closer scrutiny, it may not be. So perhaps we're letting laws get around the free exercise clause too often under the Smith standard. So that's the I guess the path to give the Supreme Court that's a little bit less muscular than overruling Smith and say, well, let's narrow it. Let's say that Smith applies a lot less frequently than we've been saying. I think I'll be interested to see, for one, whether cert is granted here, and if it is, whether it's granted on all three questions, or whether it'll be focused on the second question here. But I think ultimately it's a really good cert petition because question 2 and question 3 kind of bleed into each other, right? Because question 2 says, look, it's very hard to figure out what's neutral and generally applicable. Maybe it's not as easy as it appears, and clearly it's not because there are splits in lower courts. Nobody quite knows how to apply Smith or figure out when a law is really generally applicable. So yeah, we could narrow Smith down, but really we should overrule it. So I think it's a really well done brief. We'll be following this closely and see how this plays out. But I know people in the religious liberty movement have been looking for the right case to overrule Smith for quite some time. And we'll be interested to see whether cert is granted, particularly on the question of whether Smith should just be overruled. All right, now let's wrap up by going to Minnesota. This is probably a somewhat familiar fact pattern to people who are listening to this podcast, but it gives us a vehicle to, for one, give you an update on what's going on when high court decisions are being applied at the lower level, but also I think to opine on a couple of the key issues that remain in the area of religious schools and public funding. So Minnesota has this post-secondary enrollment option program, which a lot of states have. People are probably familiar with them, where basically high school students can apply to take college courses and get college credit while they're still in high school. And this program in Minnesota provides tuition reimbursements for students enrolled in these programs. So historically, any educational institution, public or private, was eligible to apply for this PSEO program. In 2023, the Minnesota legislature added two qualifications that are the subject of the lawsuit that was just decided. So one is the no discrimination clause, which states that if a school, a college, or university discriminates on the basis of a whole number of protected classes, including on the basis of religion or sexual orientation, that they can't participate in this program. And then the other add-in was the faith statement ban, which prohibits schools from participating if they require students to sign a statement of faith as a condition of participating in the program. So you have the faith statement ban and you have the non-discrimination ban. And a district court judge there in Minnesota recently ruled that the faith statement ban violates the free exercise clause and cannot be enforced. If anybody listens to this podcast at all or follows this line of cases from Trinity Lutheran to Carson v. Makin, the reasoning in this case is not going to be a surprise to you, right? The opinion explains that the law is subject to strict scrutiny and fails strict scrutiny because it specifically targets religious schools, right? If you have to sign a statement of faith, you cannot participate in this this government funding program. Other institutions might require non-religious agreements, right, that exclude overt references to faith, but they still have some kind of agreement that the students have to sign on to, right? Codes of conduct and whatever else. And those secular schools wouldn't be subject to the ban, right? If you didn't have a requirement to adhere to, Christ-centric values, that'll have you excluded from this program. But if there are reason-centric values or humanistic values that you have to sign on to before being a part of the program, that's not going to exclude a school from this program. So clearly the law is not neutral toward religious exercise. And so we get back to the clear Carson v. Makin rule, right? Once you open the door to private schools to participate in these generally available public funding programs, then here we are, right? It's a government funding program that says, hey, we're going to use government funding to allow public school students to participate in private school tuition programs, and all colleges and universities can offer these programs and receive the public funds for those tuition dollars for the high school students, except if you have to sign a religious statement. This is exactly what was prohibited in Carson. You cannot just exclude religious organizations for being religious from an otherwise generally available public funding program. So the reasoning that, again, is familiar here, that exclusion of faith-based schools, but no one else, it's not required by the Establishment Clause, because treating religious organizations as equal with other organizations is not establishing a religion, right? Allowing a high school student to get his credits from a Catholic college or a Protestant school or a Jewish school is not establishing a religion, because you're not picking one religion and funding it. And so this is the important line that was drawn most clearly, I think, in Carson, is that you have this balance of, if something doesn't violate the Establishment Clause, it's probably required by the Free Exercise Clause in this case. So what happened in Carson, I know this is a little remedial, but is that what the main authorities in Carson said was, well, we want to keep religious organizations out of these tuition reimbursement programs because we don't want to get close to establishing religion. We don't want to appear to be establishing religion, even if funding these schools wouldn't be strictly banned by the Establishment Clause. And what Chief Justice Roberts said in his opinion is, no, if it's not if the exclusion of a religious organization is not required by the Establishment Clause, then excluding the religious organization violates the Free Exercise Clause. That's generally how it goes. Governments can't just, prevent religion from these programs in the name of not getting too close to establishing a religion, right? If the Establishment Clause doesn't require it, then it's not within the government's purview to do it. So the analysis is often as simple as that in these school funding program cases. But I want to point out two things that I think are really important going forward that are highlighted in this case. First of all, the judge's opinion here clarifies that private schools that accept public funding are not state actors. And so the schools don't engage in violations of the Establishment and Equal Protection Clauses by requiring statements of faith. This is interesting, and it's an important point that's added into the decision because I think this issue will likely find its way up to SCOTUS, probably involving charter schools in the near future. This came up in St. Isidore. This was the under-discussed part of the St. Isidore, Oklahoma case that was not really decided this past year when there was a 4-4 split and no precedential decision made. But the consequences are quite serious. We do need a ruling that I think that says receiving government funding and that has some strings attached, right? If there's a contract, that doesn't make you a state actor, right? If it did, the ramifications go beyond school, right? If public funding coupled with a contract or policy from the government turns a private organization into a state actor, this has massive ramifications, right? Every charitable or religious organization that accept government funds, think of soup kitchens or housing organizations that help feed and clothe and house the poor. Think disaster relief by religious organizations that step in the wake of a hurricane or an earthquake and take government grants to go help do these important humanitarian works. If a government funding with a contract or some strings attached makes you a state actor, this is a huge problem, right? Because then all of a sudden, all of the requirements and rights found in the Bill of Rights and elsewhere become requirements because now that private religious organization is a state actor. We don't want to go there. I think it's a crazy way to read the law. And so hopefully we will get a precedential decision here. The Minnesota district court judge is clear that no, private schools that accept public funding under this program are not state actors, but hopefully we'll get some precedent in the near future making that clear that this is not the case. One more note. So I mentioned at the beginning that besides the no statement of faith requirement, there was this no discrimination requirement from Minnesota schools. And I think it's relevant because this is going to come down the pike and this is going to be a conflict in the coming years. So Minnesota, as I said, tried to keep religious schools out, not just through the you can't require a statement of faith provision, but there was also right, if you discriminate on the basis of sexual orientation or religion in your school policies, then you can't take advantage of this program. This is an issue because I think this is going to become and has already become a key workaround for governments that are hostile to traditional religion to discriminate, ironically, in the name of non-discrimination, against conservative religious organizations without doing so directly, right? So the kind of line, if you took out the no statement of faith ban and we just had the no discrimination ban from Minnesota, it would be, hey, we don't ban religion. We're not excluding religious schools for being religious. What we're doing is we're excluding organizations of any kind that discriminate on the basis of LGBT status, right? So it's kind of clever because it's not a general program where they're just excluding religious schools as religious. So you're kind of trying to tiptoe around the Carson v. Makin precedent, I think. But this is going to be a problem because it's a convenient way to exclude a particular kind of religious organization, right? To say that the traditional Christian or Jewish or whatever other religious organizations that have traditional teachings on marriage and sexuality, they're discriminating against people on the basis of sexual orientation or gender identity or what have you, and that's why they're being excluded for from government programs. That's going to need to be dealt with because I think the intent and the effect is only going to be to exclude religious organizations from these funding programs, but it's not as clear as it is when you just have a straight, no statement of faith, no religious organization ban. So look out for that. We will definitely see cases coming where this continues to happen, where general prohibition against religious organizations are struck down under the First Amendment, particularly quoting Carson, and then these states and localities will amend their laws and say, okay, it's not a religious ban, it's an LGBT discrimination ban, and someone's going to have to decide that eventually. I'll just note, in this case, the court didn't have to decide this issue, and they say so pretty briefly. And the reasoning is that, well, in this case, the faith statement ban and the non-discrimination requirement are actually inseparable. They're two parts of the same amendment. And since the faith statement ban is unconstitutional, the second is automatically struck down because the one goes with the other. So it wasn't decided in this case, but I do see that as something that is going to come up in a future case.
Yeah, I was certainly glad to see the state actor question come up again in the court's decision that a private entity doesn't become a state actor when they receive public funding. And that seems intuitive, right? In the private sector, this is how loans and grants work. If a small nonprofit received a grant from a bigger organization, I don't know of any time where a larger organization then says your work is our work necessarily in all instances, right? And with student loans, it works kind of similarly. It's just a parallel, but if a bank gives a student a loan to go receive their degree, the bank would never say, that's our degree, like we did that. So yes, there are always strings attached to funding, but the argument that the recipient's activities are necessarily and always the larger organization or the funding organization's activities, it just seems pretty counterintuitive. So I was very glad to see that issue come back up because, like you mentioned, that was pretty central in the St. Isidore case, and just understanding more properly the jurisprudence on this is really important, especially as in the last few weeks we've talked a lot about the expansion in public funding opportunities for religious organizations, right? With the disaster loans from the Small Business Administration, lots of public banking regulations. As religious organizations have a greater capacity to receive federal funding, it's important to clarify that receiving that funding doesn't necessarily turn them into an arm of the government.
Yeah, lots to think about, lots to watch. And I'll just conclude by saying it's always satisfying to us to see. We try to follow cases early on and see what's coming up the pike. So on the second case we covered, great to see a potential cert petition that, if it's granted in the Kathy Miller cake baker case, that will go up. But also seeing how the big precedential cases that make the big headlines trickle down and are applied. So again, the Minnesota District Court case, it's a local case. I don't know if it'll get appealed. I don't think so. But good to see the cases that maybe fly under the radar, but they're very important because they show how courts are applying what's been done at the high court. So some good news this week, and I think we will wrap up with that. So thank you all for joining us for this episode of the Napa Legal Podcast. If you enjoy the content we're putting out, we appreciate it. If you like the podcast, subscribe to our channel on YouTube, on Spotify, wherever you're listening. And if you like the work we are doing and you want to support it, you can visit our website, and we always appreciate donations so that we can continue doing the work that we're doing. We hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty, and particularly the work of faith-based nonprofit organizations. We'll talk to you next week. Thanks for joining us, and God bless you all.